Representative Beck, you're recognized.
I guess my question is on the amendment. With your amendment, Mr. Sponsor, the civil damages that you were referring to, if, for example, a terrorist comes into my church and makes a phone call, the church has no connection with that terrorist, it's still going to open my church up to a cause of action. Is that correct?
My understanding is the bill leaves a lot of room for those types of cases, and let me read to you exactly what it says about that. The owner or interest holder acquired no interest in property, money, and other assets shall be seized or be subject to forfeiture pursuant to this section if the court finds at least one of the following. A, the owner or interest holder acquired the property before the conduct alleged to give rise to its forfeiture. The owner or interest holder acquired the property during or after the conduct alleged to give rise to the forfeiture, and the owner or interest holder acquired this interest as a good faith purchaser. The owner acted reasonably to prevent the conduct giving rise to the forfeiture. The owner did not know the acts were being committed that resulted in the forfeiture, and no interest in real or personal property, money, or any other item subject to forfeiture under the section shall be seized or forfeited unless the owner or interest holder is convicted of a crime or crimes prohibited by this part. If the owner or interest holder is an entity other than a natural person, the property shall not be forfeited unless the entity's officer, employee, or agent is convicted of the crime or crimes under this part, and the state shall also have the burden to establish beyond a reasonable doubt the following additional elements.
Now, the way you just read that, knowingly or unknowingly, the knowingly becomes a question of law, correct?
Absolutely.
And that question of law is litigated, correct?
Correct.
In a civil court, where you have just the preponderance of the evidence, not the burden of a criminal court, correct?
Let me just confirm that's the case with the civil.
Okay.
I have to assume you're correct, yes, sir.
If we pass this amendment, we are opening up. Being a lawyer, I should love this, just to be quite honest with you. But the standard that I raise my nonprofits and my church to would not allow me to vote for this amendment.
Thank you. I think there are very reasonable protections for any innocent third party built into this.
You're recognized, Chairman Carter.
Representative Matheny, thank you so much. Here's my problem. I've just sat down. I haven't read this bill. I haven't seen the amendment. I have absolutely no idea. I know what I think you're intending, but I haven't even had a chance to read this, and I just don't know how to do that. I just need some time to understand it.
I know you're a good reader, sir. You've read the
Well, boy, I'm pretty burnt out.
Well, I understand that. We're all burned out. And let me say this bill is moving very well through the Senate on a strong bipartisan vote. I would be more than willing to park, if we can get it to sit down and make sure you're comfortable with it before we move it further and alleviate everything at that point.
I'm good.
Absolutely would. Any member has an issue with it, I'd be glad to do that.
Yeah, Senator Harris, you recognize.
I don't know if this question is for Mr. Tyre or for the sponsor, but I'm assuming the bill only applies to people convicted of the act of terrorism.
Chairman Ketron?
That's my understanding.
Okay. Mr. Ty?
Thank you.
Yes, that particular forfeiture procedure is judicial and it requires conviction.
And does the civil right of action, Mr. Teig, also apply only if there is a criminal conviction?
I would say the civil right of action under this act, I would also say there's probably existing, this would be an intentional tort, so I would think there'd be an existing cause of action that's would be regardless of conviction.
Okay. And also, while we're in recess, Mr. Teig, one question on the statute of limitations. It is, as Chairman Ketron pointed out, 5 years from the date the cause of action accrued. So based on that wording, I'm assuming then that the discovery rule would not toll that cause of action because the date that it accrued would be the date that it accrued, or would that toll it?
I don't think it would, no. That's a question I haven't actually thought of. I don't think so. I mean, we can certainly find that out at some.
Okay. I guess I was just thinking, well, I guess in theory it could toll it if you didn't discover the injury until many years in the future, but I think with this particular statute, acts of terrorism, everybody notices those immediately, so I don't think it would be an issue.